Joining us now on the debate for the full hour tonight, Mr. Justice Dennis O'Connor, the Associate Chief Justice for Ontario, who presided over two major public inquiries, the tainted water scandal in Walkerton, Ontario, and the wrongful imprisonment of Mayor Arar. Lawyer Paul Cavalluzzo, lead commission counsel in both of those inquiries. Ontario Court of Appeal Justice Stephen Goudge, who headed the inquiry into the province's forensic pathology system. Lawyer Linda Rothstein, lead commission counsel for that inquiry. And Ed Ratushny, Professor Emeritus at University of Ottawa's Faculty of Law and the author of The Conduct of Public Inquiries. It's great of all of you to join us around the table tonight for what I suspect will be a really fascinating hour of television. We know that there are all sorts of public inquiries that get called. You know, Roy Romano did one into healthcare. Donald McDonald did one on free trade. Those aren't the public inquiries we're talking about tonight. We are talking about the kind when the Premier has a problem and he needs you folks to fix it. Judge Goudge, to you first. The media is all over a big story. They've learned that a so-called star pathologist, Charles Smith, appears to have made significant errors when testifying in criminal investigations, and the result is a lot of people may have gone to jail unjustly. The Premier and the Attorney General, I gather, decide that the public may have lost confidence in the justice system, and so they call you. How does that phone call go?
It happens on a Saturday night, out of the blue. The Attorney General phoned, I was at home, and he simply asked if I would be prepared to take on a public inquiry. The story had been in the news for the previous couple of days, and it was obvious the government was thinking about a public inquiry. And the Attorney General made it clear he'd talked to the Chief Justice of the province and the Associate Chief Justice, and they'd given their okay for me to accept if I thought I should. And I reflected on it, not long, I confess, and agreed to do it.
How much information do they initially give you about what they want you to do?
About 5 minutes.
5, so not too much, I guess.
No, and you know very little except what you've read in the newspaper. There is a public controversy, often a tragedy, and you know very little more than what you've read in the newspaper.
Do you know why they call you as opposed to some other judge?
No, I had no idea why they called me.
Do you sometimes say, why me?
I did later on.
Okay. Dennis O'Connor, we're going to run the same scenario with you. Walkerton, Ontario, population 5,000. They discover that the drinking water is contaminated. 1,300 people have gotten sick and 7 are dead. It's a crisis. Who calls you from the Ontario government?
Actually, I was called by Chief Justice McMurtry, who was the Chief Justice at the time, and he had been called by the Ontario government. I was in the Yukon, sitting up there, and he called me one night, and I knew of what had gone on in Walkerton, and asked me to come back and to see if I would, and we then had discussions with the Ontario government about me being involved in the inquiry.
And again, that call from the Chief Justice, then Mr. McMurtry, how long a phone call is that?
Well, we talked, I count 15 minutes. We talked about what would be involved in terms of what we knew at the time, the potential scope of the inquiry. We were both concerned about seeing the terms of reference before I agreed with his consent to do it. And so that I came quickly back to Ontario and began some discussions with the Ontario government.
Do you have the option of saying, thanks, but I'd rather not?
Yes. I think any judge or Chief Justice has that option. And I think that's very important, that there would be some inquiries which would not be suitable for a sitting judge to do. And so that I think careful consideration needs to be given right at the outset when the request comes from government, whether it's the provincial or federal government, to see if this is indeed an inquiry which is suitable for a sitting judge and which a sitting judge could conduct effectively.
Judge Goudge, how much hardball are you allowed to play insofar as can you say, well, I'll do it as long as ...
It seems to me that the decision to call an inquiry is obviously for the government, and in a broad sense, the public policy area they think requires an inquiry is for the government. I think the judge who was asked to take it on has a good deal of leeway to discuss with the government the way the process unfolds to make sure that it's efficient and can be done in a way that is open and independent, because it's very important and the public expects an inquiry to be independent. So for a judge to have input into the structure of the inquiry and its process, I think is quite important.
You ever turn one down?
Have I ever turned one down? No.
So you've been asked once and you've done one?
Yes, I'm 1 for 1. The next one I perhaps will reflect on a little more.
Now, well, I'll get into later whether or not it's something you wish you hadn't done. Judge O'Connor, at what point do you say, I need this much budget, I need this much staff, I got to make sure I'm happy with the terms of reference. If I don't get this, I'm not sure I can participate. When do you have that conversation?
Yeah, the first conversation, and perhaps the most important one, is the conversation about the terms of reference. The person, whether it be a judge or someone else who's asked to do it, has an interest in ensuring that the terms of reference are specific enough and thorough enough that whatever is troubling the public can be investigated, so the inquiry will have credibility when it sets about its task. On the other hand, there's on the other side of that, it's important that the mandate not be so broad and so general that the inquiry could go on indefinitely and suffer the way some inquiries have. It's difficult at the outset to have a discussion about the amount of money it might take. Sometimes you might have a general discussion about the amount of time it may take. But in my experience, those discussions come later, once you've had an opportunity to begin the investigation and have an informed view about what's going to be involved.
Now, that's a good point. Is this a full-time gig once you sign on?
Yes, it is.
You can't listen to any other cases while you're doing it?
Usually, in my case, and I think Steve's, is what we did, is we would have phased out our existing workload and then devoted all of our time. And typically, an inquiry will last a couple of years.
Okay, so the Attorney General or the Chief Justice makes the phone call. These two guys are in, signed, sealed, delivered. Now we come over to this side of the table. Linda Rothstein, he agrees, Judge Goudge, to do the inquiry. He needs a lead commission counsel. In this case, it was you. How do you get brought on board?
I think it was about 24 hours after Justice Goudge had agreed to do it, but before it was publicly announced that he called me. And I don't know to this day whether I was the first call or not.
Should I find that out for you?
Sure.
Answer absolutely yes.
Okay.
And so we had about 24 hours together to talk about it. I think he called me and asked me to do it, and I didn't know that he'd been asked to do the inquiry at all. And he just said, will you help me? And I quickly realized what had happened because I'd heard about the inquiry, and it just made sense that Justice Goudge had been asked to do this.
Did you know what will you help me meant?
It took me about 10 seconds, and then I knew, and I think I instantly said yes.
And then what is the job? Now that you've got it, what does that actually involve?
Well, it's probably the most demanding job I think that I've ever had as a lawyer, because you've got a very a complex file, and you've got a client whose reputation in part depends on the way in which you conduct yourself as their counsel.
Who's the client?
My client is Justice Goudge and the commission itself.
Okay.
And in fact, I think it's Justice O'Connor who's first formulated the idea that as commission counsel, we act in a way as the alter ego of the commissioner to a large degree. We are their spokesperson, and we do take the position that they want us to take in terms of the contours of the inquiry and the way the investigation is conducted. So you have a very close relationship with the commissioner in terms of every aspect of the inquiry, from its initial design to the implementation of that design through the hearing process.
Gotcha. Paul, same question to you. You've done two with Judge O'Connor. How do you get brought on board?
Well, in the first one...
And do you want me to find out if you were the first choice as well?
Well, in Walkerton, actually what happened, ironically, it was Stephen that phoned me, asked me if I would be interested in it, because I knew Stephen better at the time than Dennis. And then about 15 minutes later, Justice O'Connor called me and asked me, and I actually was in the backyard at the time. I talked to my wife and my family, and then decided it would be a great idea to do. And I did that, and then in respect of the Aurora inquiry, I was watching the news one night, and Justice O'Connor called, and I said, oh God, no, why me? And I said yes again. And
Why the different reaction on the second one?
well, because it takes so much time. As Linda said, it's the most demanding job that a lawyer will ever do, and it's the most challenging and probably the most rewarding as well.
So you want to do it?
I want to do it, yes.
Will either of you, Linda, to you first on this, have any contact, if you're the judge's alter ego in some respects, will you have any contact with the government of the day?
You do. I mean, once the terms of reference have been set, and it's a question of making sure that you act within that mandate, you have to deal, for example, in my case, with the Deputy Attorney General over the way, for example, they want us to invoice.
Okay, but that's civil service. How about the actual Attorney General, a politician?
No.
No contact with them?
I had none.
Paul, how about you?
Only as witnesses.
But not sort of behind the scenes for you. Would that be considered inappropriate?
Well, it depends on the circumstances, but I think in most cases you've got to be very careful. It could be viewed to be inappropriate, yes.
Okay. Now we bring in this guy here, who wrote if I may show it, 475 pages of the conduct of public inquiries, a very exhaustive and thorough investigation, if I may say, and very helpful to putting this program together. And we should also add on the Hill Times top 20 list, crack the top 10 actually, of important books published in the past year.
I love you.
Okay, there's any number of different ways that politicians can respond when crises happen. They can call a press conference, they can send a minister out to do something, parliamentary committee, legislative committee, all of the above. But every now and then they go full bore and they call a full public inquiry. What are the conditions that tend to be in place for them to take this very exhaustive, very thorough, very expensive option?
That's really the heart of the whole matter. A public inquiry is a residual mechanism of government. It's invoked when everything else is inadequate. The ordinary political process, the courts, parliamentary committees, none of them are suitable to do the job. There are certain features that a public inquiry has that renders it capable of getting the public's confidence. And that's the bottom line. And those features of public confidence are essentially that the inquiry is independent. That's why they often have judges who have a stature and reputation for impartiality and independence. They're effective because they throw themselves into it. As they said, day and night, it's just an onslaught on the terms of reference from the moment you start until you finish. The terms of reference are designed very specifically to identify and attack the problem that the public is concerned about. And they have the powers to subpoena people, to gather all the documents they need. They have those coercive powers. And finally, it's completely transparent. The public sees everything. Everything comes out. And the public retains that confidence if an inquiry has been conducted properly. These were two excellent inquiries. They're models.
Excellent in what respect?
In the respect that they responded so comprehensively and completely and quickly with such sensitivity and such good judgment about how they carried out their mandate.
Given your study of it, this is where the political system reaches out to the judicial system and says, help us. Do you know in any of your research whether or not there was an occasion when the political system reached out to the judiciary and said, help us, and the judiciary said, thanks, but no thanks. This one's really too messy and sticky and you're on your own?
Well, I don't know of any examples of that, but if there were examples, I'm not sure they would have been publicized. I'm not sure that the judge, for example, would have said that he or she turned down an inquiry. But there have been examples of inquiries and governments going to war. And Paul, for example, had, you didn't go to war, but you had confrontations with the government in Walkerton on the privilege with cabinet documents. You had national security confidentiality. And in both of those situations, and you may want to hear what Paul has to say about how he resolved those, they were resolved. In Somalia, they never got resolved.
No, they shut it down.
They went, exactly.
Yeah, we'll get to a little bit more of that later. We heard Judge Goudge, the two lawyers, say this is something that really is the kind of capper of the career. It's a big deal, and they wanted the responsibility. Do judges want to head up public inquiries?
I think judges would often, perhaps even always, Steve, when a phone call, like the phone call Dennis described or I described, feel some obligation because there's a public interest involved, and judges are in the business of doing the public's business, and this is important. So I think judges would very frequently feel some obligation to say yes.
Judge O'Connor, a lot of judges I know like being judges because they're not in the public eye. They're not in the center of the media circus or storm, and that's a good, you don't get that when you're in a public inquiry, right?
No.
So do you ever think about
Yeah, you do.
not wanting this responsibility for that reason?
It's certainly something I considered when I took them on. It is, as you point out, different than our day-to-day job as judges. By and large, we will make decisions that will be in the press, but by and large, our day-to-day fare we do in courts, and the parties are aware of the results, and we stay out of the media. The public inquiry thrusts you into the media, if not daily, frequently. And some parts of it are covered live on television. In the case of Walkerton and parts of Arar, there was media representatives assigned full-time to cover it. So that is an aspect of it that if you're going to take on a public inquiry is just part of the way it is, and you must get used to it. I think I would probably speak for many judges, it's perhaps not the favorite part of doing a public inquiry to be sort of in the media that way, but I don't think there's any option. And indeed, I think one of your obligations as a public inquiry commissioner is to ensure that there is the transparency and full sort of disclosure to the public of the evidence you're hearing and how the proceedings are being run, so that I think you have a positive obligation to do that.
Otherwise, it kind of defeats the purpose of it, doesn't it?
Absolutely, yeah.
What does it say about how we regard the judiciary in this province that when politicians get into a heap of trouble, Paul, they often call these guys?
Well, I think what judges bring to bear are several things. Most importantly, as Ed said, it's the independence from government, because mostly public inquiries relate to the conduct of government. So they bring the independence. The other things they bring to bear are fact-finding, assessing evidence, providing fair procedures, because it's very important in a public inquiry that the process be fair. So that they bring all these attributes, impartiality as well, and because of that, the report that will be delivered by the judge will have far more credibility for the government at the end of the day, and the public will have more confidence in that report.
Linda, do you want to add to that?
There's usually a lot of legal issues that are addressed behind the scenes that are really thorny, and there's absolutely nowhere you can really look to get a clear precedent. The public-private problem in every public inquiry is extraordinary. How you protect the privacy interests of all kinds of people. For example, in our inquiry, we had families who were bereaved, who had lost children, who had often been accused of very serious crimes, who were going to be the subject of criminal proceedings, that was going to be ongoing, who were the subject of civil proceedings, and who had, nevertheless, very private grief that they wanted to share, and trying to figure out a process that would allow them to at least address that aspect of the matter without being the subject of cross-examinations that interfered and probably undermined the legal proceedings, required, in my view, a judge's understanding of the way we balance public-private interests in a legal context.
Yeah. Ed,
so that's an important role.
We mentioned off the top of the program there are, of course, public inquiries or royal commissions, that kind of thing, that don't have judges at the head of them, that often look into public policy. But for something like this, where there's a clear scandal that's been all over the papers all the time, can you imagine anybody sort of short of a judge heading it up and having the same kind of credibility?
Well, I guess these two lawyers here probably could act as commissioners quite as effectively, but that stature of a judge, the independence and the special aura of the judiciary in Canada is so special that it brings a lot of value to public confidence.
Okay, let's now move from sort of the setting of the table to the judge's authority as we go through this thing. And again, Linda, let me start with you here, and we're going to try and figure out more about this relationship as it goes along. You're the kind of eyes and ears of the judge. Yep. You consult all the way through. What happens if, during the course of running Judge Goudge's inquiry, you two disagree about how you're supposed to proceed? What happens?
But you do have conversations where you don't start off agreeing. I mean, that's what's healthy. I mean, I actually don't think that Steve would have picked me if he thought all I was going to do every day is say, yeah, that's a great idea, because they're complicated issues. In the end, we didn't have any difficulty getting to, I think, a fair answer, and I think he led that way. But I think he was expecting me very often to take a position that wasn't exactly the position that he first came to the table with.
True?
Absolutely. I mean, I wanted Linda for the advice she was going to be able to give me, and it wasn't always advice that I'd be inclined to myself, but it was always persuasive. We, in the end, didn't have any significant disagreements. So the role of commission counsel is very, very important in the way the inquiry unfolds.
If you do have a problem, do you at the end of the day have to say, I'm the judge, we're going to do it my way?
Yeah. At the end of the day, the commission is the responsibility of the commissioner from the beginning right through to signing off on the report. And that's one of the things you're most conscious of when you take this on. That in the end, you're the one that has to be responsible for turning over to the government the very best inquiry document you can produce.
Now, I guess, Judge O'Connor, the first time you worked with Mr. Cavalluzzo, it worked out well enough that you decided to ask for him again.
Absolutely.
Okay, so I guess there were no fisticuffs or anything like that. But when you do have a disagreement about how to proceed, how do you handle it?
We discuss it. I mean, just we talk about it professionally and sensibly, and my experience was the same as Steve and Linda's, that we were able, when we had disagreements about process or procedure, to talk our way through to what we thought was the best solution. The one comment I'd make about that, though, and I think Paul would agree, is that when it comes to reaching conclusions in disputed areas, say about facts, or a conclusion about competing positions, say with respect to a recommendation, ultimately the judge wears that. That's the job and that's the position. So that in relation to that, I certainly would consult Paul. I'd be aware of his views on it, but he would respect, and I would see it as my duty, that those would be my conclusions and my analysis at the end of the day.
What do you do, Mr. Cavalluzzo, if you've got a real problem with the way he's presiding?
Well, I never really experienced that, but if there
No,
was
you can tell us, really.
but if there was a problem, once again, it would be just a matter of discussion, and Commission counsel would always realize that he or she is the alter ego of the commissioner, and at the end of the day, it's the commissioner's decision that must rule.
Ed?
I acted on a Royal Commission in Newfoundland, and the commissioner was the former Chief Justice of Canada, Antonio Lemaire. He decided to bifurcate the roles of Commission counsel.
What does that mean?
One Commission counsel acted as the advocate in the courtroom and didn't have the private ear of the commissioner without the other parties being present. A second Commission counsel, which was the role I served, was as advisory counsel, and he could talk to me about anything, and we'd go back and forth, and I got involved in writing the report and so on, but I didn't say a word in the hearing room. So all of the parties knew that anything that hearings counsel, the counsel in the hearing room, anything that was said to the commissioner by that counsel, everyone heard, people could disagree with, they could argue against it, and the commissioner could rule against his own counsel. And that actually occurred a couple of times. So it's a different model, a newer model.
I did ask you two whether you had contact with the government during the course of it, but I didn't ask you two. The government calls you to to get you in the business. Once they've made that phone call, do you have any contact with anybody from the provincial government after that?
The only contact I had was with the deputy minister in the few days right after the Attorney General called me, and that was over discussions about the terms of reference.
So no politicians?
No politicians. The only politician I saw was the Attorney General when he phoned to invite me to do it, and the Attorney General to whom I delivered the report when I was done.
Would you have considered it inappropriate if any of them had contacted you?
For me, the independence of the commission is vital, and I think the government respected that, certainly in my case, and I think in most cases. I think that's the Canadian tradition, that the reason these inquiries are set up is in large part because the government sees it to be in the public interest to have an independent look at a significant crisis or a significant public policy problem. And it goes with independence that the government sets it up and then lets it do its work.
Now, yours was a little different because when you did Walkerton, you had politicians testifying.
We did, and we did in Aurora as well. And but I had the same experience in terms, in one case was the provincial government, the other case, Aurora, was the federal government. And I had no contact other than when they were in the witness box with any politicians during either inquiry. I'd be most concerned if there was any such attempt to contact. I must say I also had good relations in terms of the administrative interaction, not with politicians, but with government officials in terms of the way we were running the inquiry, because the government has to finance it. And so that there would be obvious possibility for tensions there. And in both of my cases, the governments acted appropriately and with respect to administrative and financial matters were supportive of the way we conducted the inquiry.
Judge Goudge?
It's true that many inquiries are set up in the shadow of a crisis or a public tragedy or something like that, but I actually think when governments do this, they almost entirely are anxious for the independent advice that comes with an independent commission. That's in large part why they're set up. It's obviously has the result of getting a problem off the front page of the paper. But I think there's a legitimate desire on the part of government to get independent advice on very difficult public policy issues.
Did you feel, Judge O'Connor, any need to treat the politicians who were, I'm trying to remember now, did Mike Harris testify at your?
He did at Walkerton.
Premier Mike Harris.
Yes.
First time in 50 years a sitting premier testified at a public inquiry.
Right.
Did you feel any obligation to kind of carve out a little extra, I don't know, space or respect or something for him because he was the sitting premier of the day?
Well, I was certainly very aware of it, and the decision to call him was one that I only made after a lot of anxious consideration. I mean, I understood the significance of it. I was satisfied that the evidence led in that direction, and in order to be thorough, it was necessary to do. I've said this on other occasions that Paul Cavalluzzo examined him, and over the course of one day, or part of one day, and then he was cross-examined by a number of the parties. I thought that the way Paul handled it, given that he was a sitting premier, that he did an absolutely outstanding job. He was thorough, he was fair, he was balanced, there was respect, as there should have been to a premier. There was no cheap shots, nor was there from any of the counsel who cross-examined. So that, no, I would say that he was questioned about the evidence that was relevant to the issues that we were dealing with.
Make you nervous having him sit there?
I mean, it was one of the sort of higher tension moments of the inquiry, if you will. It was in Walkerton, and there was obviously a huge amount of press coverage of it. But at the end of that day, it was a long day. I was pleased that it had been carried off, not due to me, but to the way that the examination was conducted in an appropriate fashion.
Paul, what about it? Was there a little extra, I want to use the right metaphor here, maybe I better not find one, when Mike Harris testified for you?
Well, if you can believe it, the day before my son was graduating from St. Michael's College in Toronto, so I had to drive that down to Toronto and then drive back to Walkerton.
That's a long drive.
It's a long drive. So it was the first time, and it was in the papers, the first time a premier had been called as a witness in, as you say, 50 years. So that there was a great deal of stress. There was an anxiety. The courtroom was filled. There was all kinds of press. It was going to be on, it was covered actually, the whole thing on a couple of TV stations, so it created that kind of...
What's your approach, though? Do you feel you have to be on your best behavior because it's the premier? Or do you feel you have to go at him harder because it's the premier?
A bit of both. A bit of both. He is the premier and it obviously is deserving of respect, but at the same time, if you felt that he wasn't answering questions the way you felt he should, then you had to be firm, but in a respectful way. So
Do you have any contact with him afterwards?
Actually, I ran into him at a cocktail party when one of my friends was becoming treasurer of the Law Society, and it was in a big boardroom at a law firm. He saw me, I saw him. He went to one end, I went to the other.
So no contact.
No contact.
I was going to say that'd be an awkward conversation. Ed Ratushny, you wanted to say.
Well, when you think of it from the point of view of the public, could you ask for anything more? There's the public seeing the premier of the province having to answer to the inquiry. These people have done their homework, they've done all the interviews, the preparation and so on. They get the premier of the province there answering to them what went wrong, why did it go wrong, what did you do and what didn't you do. I mean, the confidence that engenders in the public has to be massive in terms of really getting to the bottom of things.
It's a bit nervous time too, though, I would think. 'Cause, I mean, if memory serves, there's a bit of I shouldn't call it a lynch mob, but there were pretty angry people waiting outside that room. And the premier had to walk in and walk out with a lot of screaming and shouting going at him. I mean,
It has to be handled really well, and it's really a credit to Dennis and Paul that it went as well as it did. I mean, that's, I think, what you were saying earlier, Ed, that, you know, it takes a deft hand to be able to manage that kind of crisis. Not crisis, but that kind of tension and potential difficulty the way they did.
Do you worry
it takes
about
a very deft hand.
a circus atmosphere being created with that kind of thing?
I do, yes. I think conducting a public inquiry, there's an intense amount, a lot more publicity in a public inquiry than there is in your average court case. And so that people who are called as witnesses, not just the premier, but other witnesses, are going to be subjected to more public scrutiny and media attention than likely at any other time in their lives, and often in a very negative context because something's gone wrong and they're being questioned about it. And I think there's a very high obligation on those running the inquiry, the commissioner, commission counsel, perhaps even more directly, to try to not sensationalize unduly what went on or sensationalize it, to lead the evidence in a balanced and restrained way, to get to the facts in a professional way, but not to sort of give in, if I can put it this way, to media hype.
Judge Goudge.
I think that's one of the biggest challenges in running a commission, and it's the responsibility, as Dennis says, in large part of commission counsel. But while you're in the business of trying to find out what went wrong, it's not so much for the purposes of casting blame or criminal responsibility or civil liability or anything like that. It's with a view to providing a foundation to try to make recommendations to the government so this kind of thing won't happen again. And I think you always have to keep in mind that what you're doing is trying to get at the facts for the purpose of making recommendations that are going to allow you to hopefully help in the future.
Okay, but are you in charge of security at these things?
What do you mean by that?
I mean, at your inquiry, for example, there were no doubt families there of people who'd been put in jail wrongly, and emotions ran high.
There was no doubt that we had the same kind of emotion that Dennis described in Walkerton, and to a degree, an inquiry does provide an outlet for that. We each conducted informal parts of our inquiries that addressed that might be worth a mention, but in the formal part of the inquiry, it's very important that Commission Counsel and the Commissioner keep the tone as reasonable and civilized as possible.
Okay. Got a quote from your book now, Mr. Ratushin, if you don't mind, do you?
Thank you.
Okay. If you don't mind.
He's been waiting.
It's about time.
This is a quote related to what happens when public inquiries kind of go off script, which does happen and has happened recently. Okay, let's put this up, Michael. Launching a commission of inquiry is a risky process, a bit like sending a ship out to sea. You don't know where it will go, how long it will take, how much it will cost, or what it will bring back. And trying to relocate a ship lost at sea and bring it back to port can be a costly experience, especially if the captain is not in a hurry to come home. That's a great quote. Okay, Ed Ratushin, I'm going to start with you here. I guess probably the most, is infamous too pejorative a word to use in this case? I don't know. Let's use it anyway. The pedophile situation in Cornwall, Ontario, where a public inquiry was called. By many accounts, the thing went on much longer than it was supposed to. It cost a lot more than it was supposed to. It ventured into areas the government didn't expect it to venture into. And at the end of the day, critics said, we really don't know any more than we did than the day this damn thing was called in the first place. Watch my language, sorry. When a government sees this happening, what can it do?
Well, it can put a limit on the inquiry, which is what Cornwall didn't have a time limit at the start. And they finally put a limit, and the inquiry had to finish its work. I think one of the problems in these situations is that commissioners and their staff, if they're inexperienced, don't realize that this isn't just like sitting in a courtroom and waiting for everything to come to you and making an adjudication. You're managing a budget of millions of dollars, you're managing people, you're managing the press, public expectations. It's a very, very complex task. And unless the commissioner leads and takes the staff and everyone along on a mission that we've got to get this done and we've got to get it done fast, we've got to respond to the people. I think the O'Connor inquiry had staff on the ground within a couple of months interviewing the victims and giving them a chance to speak, and the same with the Goudge inquiry, meeting privately with the families of people. This was going on behind the scenes, but it was work being done right away. They were both very conscious of their time limits, and I don't think Justice O'Connor had a time limit in Walkerton.
I did.
But you finished it in what?
Just under 2 years.
Just under 2 years, which was remarkable. And you did have a time limit which was extended for a very short period. What, 18 months you finished it?
17 months all in.
17 months, which is extraordinary when you consider.
Tell us why that's considered extraordinary.
Because of
2 years sounds like a lot of time to be working on one thing, you know?
How many cases would you have been involved with in your?
We had basically a roster of 45 cases that we had to look at, and then more importantly, we had all the systemic issues that arose out of the things that went wrong in those cases, so we had to really try to get to the bottom of how the forensic pathology system in Ontario functioned and how it had gone wrong in these examples.
Judge O'Connor?
Yeah, and public inquiries, as Steve mentioned earlier, are often called to look into what went wrong, say Walkerton. But part of the mandate was also to make recommendations to ensure the safety of drinking water across Ontario. And that was a huge exercise, some of which flowed out of what happened in Walkerton, but went well beyond the issues from Walkerton. So that it's often when government creates an inquiry and then attaches to it a policy recommendation function that will cause the inquiry to take longer and to be more to spend more money. And I think both Steve and I experienced that.
Judge Goudge?
I think it's important to emphasize, Steve, the importance of the policy recommendations and the need for them to be done as efficiently and
We're going to get there. Hold off on that.
in such good time as possible.
We're going to get there. I'm not finished with the inquiry gone rogue yet. I want to go there first. Linda, hypothetical. You're the commission counsel for an inquiry. The judge is going somewhere where you don't think he ought to go. What do you do?
I think you sit down and you give him the best advice that you can, and then ultimately, as we've already discussed, it's his or her decision to make.
But you can't really bail at that point, can you?
Probably not. I mean, I can't imagine a situation that would cause you to do that.
Well, we had it in Cornwall just now, didn't we?
I don't think that the commission counsel bailed.
No, not bailed, but you know, the argument many people made was this thing's out of control and this judge hasn't got a handle on it, and what are we going to do?
Well, what I would say is it's one thing we haven't talked about. There's a lot of reasons why judges are particularly well positioned to take on public inquiries, but one of the things I suspect the government doesn't think about and maybe doesn't know is whether they're good project managers. It's actually an additional skill set that you need to run a large multi-million-dollar budget and make the trains run on time. And I can tell you that the day that I accepted the responsibility of being Justice Goudge's commission counsel, he said to me, and we are going to complete this inquiry within a short time frame. And at the time, he was hoping it could be done within a year. And we got almost everything done within that year. And it was always part of his view that he was going to run this in an efficient way. That was how he approached it from the get-go.
Paul, how about your situation? If you found yourself in that kind of situation where you thought the judge was just way, way gone, what do you do?
Well, you've got to sit down. You would have to sit down with a judge and advise the judge that you know, the kind of delay we're talking about is going to impair the integrity of the process, and advise the judge that if you're going to go beyond your mandate, you're going to have court applications, and if there's anything that's going to delay a public inquiry, it's court applications.
What does that mean?
That means that to one of the parties will go to the divisional court saying that the judge has gone beyond his mandate or the judge is acting unfairly or whatever the reason is. And that takes months. And as a result of that, it causes delay in the process, and at the same time it impairs the confidence that the public has in the inquiry if you have a number of judicial applications. And at the end of the day, when the report finally comes out, it's going to be colored by that kind of process and that kind of delay.
Edward Tushnet.
I was just going to add that you can't just start from the point of view of the commissioner, because really there's a team involved, and the responsibility for delay and for not being efficient and so on has to be shared by commission counsel, I think. Where there's a successful commissioner, every one of the reports says, I owe a great deal to my commission counsel. They always pay tribute to that, and it's because commission counsel do an awful lot to expedite things, to come up with novel ideas. Let's try this. Can we do this? Will this work? That kind of interplay goes on constantly as a team. And I think it's important to keep that in mind.
Judge Goudge.
To use your phrase, Steve, if an inquiry in the view of some goes off script, I think that speaks to the importance of the order in council that sets up an inquiry in the first place. Because if an order in council is not put together in a way that produces a realistic task for a commissioner to perform, it's going to make the job all that much harder.
So just so I'm clear, like the marching orders you get
The
from the
marching
government.
orders, and if somebody feels that those marching orders aren't being followed, the legal remedy, as Paul said, would be to take the commission to court and try to get a judge to supervise the inquiry to bring it back within its order in council. So one perception of going off script is that the order in council, the marching orders, are not being followed. Another perception is the government's perception that, for example, this is getting too difficult politically. That's purely a political judgment, and as I'm sure you know, a government has the power to cancel an inquiry.
I want to follow up on that right now. Judge O'Connor, we saw this. The Chrétien government shut down the Somali inquiry. Now, I don't think it was a judge who was heading that up. It was a former journalist. I think Peter Deborah was.
No, there was a
judge
there were
too?
three
Yes,
commissioners
three
and the judge
commissioners,
was the chair, yeah.
Okay, so the government says, we're giving you this job to do. They're doing the job. Government doesn't like where it's going and shuts it down. As a, hypothetically, you're the judge on that situation. What do you do?
You really don't have anything you can do. The government has the authority to do it. The government creates the inquiry, and it has the authority to shut it down. And if it's prepared to pay the political consequences of shutting it down, then so be it. But from the judge's standpoint, the judge really has to just live with it, and I would suggest not get into a political debate publicly about the fact that the government did it. I would suggest if that happens, it's going to be rare, the judge should go back to his or her job and carry on with the judicial duties.
Yeah, just as it's an executive function to set up an inquiry, it's a function of the executive to shut it down if they don't like the political direction the inquiry is taking.
But we saw in that case, they shut it down with no political ramifications at all. I think Chrétien won another majority government after that one was over. So does that give you pause about the advisability of taking this thing on?
Well, there's no doubt that running a commission in a way that pursues independence is vital, and the one thing you don't want to do is to do exactly what the government might want you to do. You're pursuing the mandate as best you can.
Okay. Home stretch here. Inquiry's over, witnesses have been called, everybody's going home, except you two, I guess. Linda, what happens now? You've got everything in there, what do you do now?
Well, in my own case, it was pretty clear that that Steve was going to write the report. He had been writing all along, and he had some pretty fixed ideas, not fixed ideas, but he had an idea of how the framework of the report would look.
So that's not a given, that the judge will write the report himself.
I don't know enough, but I don't think so. I think that there's mixed views about the extent to which the counsel for the commissioner should be involved in writing. In our case, we had transcripts up. We had lengthy transcripts, and we were involved in providing summaries for the judge. And mostly what he used us for is to test his ideas. He'd come in and he'd have written out his recommendations, and then he would ask us to try and come up with arguments against them. What were the arguments against them? What were the things that could possibly go wrong if those recommendations were to be, finally part of his report? He used us to try and test the efficacy of every recommendation that he made.
Do you try at this point to convince him to include or not include particular recommendations?
Well, in the course of that conversation, you end up saying things like, well, maybe this isn't that workable, or maybe this isn't solving the problem. You end up having those kinds of discussions. But it was actually a very, very interesting way, I thought. I don't know what I would have done in his situation, but I thought it was a fabulous way of inviting, not just from me, but our whole Commission Council team, a range of views that would allow him to test the efficacy of his recommendations.
Paul, it's all over. What do you do then?
Well, we had, both in Walkerton and Aurora, we had a number of people on the commission staff, the Commission Council and others, and we were involved in summarizing the evidence, that kind of thing, but obviously the ultimate decisions were made by Justice O'Connor. In terms of the recommendations, we would sit down and we would discuss them, but once again, ultimately the decision is his, but we would participate to the extent of summarizing the evidence, because there's a great deal of evidence, analyzing the evidence, assessing the evidence, and so on and so forth, and in that way we were of assistance to him, hopefully.
Judge Goudge, how do you begin? I presume when you start to sit down to think about what recommendations you want to put forward, how do you begin to sift through what are no doubt thousands and thousands of pages of testimony, evidence, exhibits, the whole 9 yards?
Well, you have a huge body of facts about what happened and what might have gone wrong in the system that you're looking at. But beyond that, Steve, a policy inquiry, and both Dennis and I shared this experience, draws on expert evidence that's given in a forum that's very like a hearing, but also like a seminar. It's done in public, and so the judge gets the benefit of input from the wisest people in the world running these things. And so you're not synthesizing facts in a vacuum.
You wrote yours yourself?
Linda's too kind. I mean, the facts and so on were summarized by the staff. All the judgment calls I made myself and the recommendations I made myself. But I didn't cut it out of whole cloth. I had both fabulous staff and expert evidence that I had listened to with care over a number of weeks.
Judge O'Connor, before you make your recommendations, for example, Walkerton, do you ask yourself, can the government afford to implement what I recommend?
We did, in fact, in Walkerton with the recommendations in the policy part that I mentioned earlier about ensuring the safety of the drinking water system. We hired experts to cost out the implementation of those recommendations in quite a sophisticated way, and they looked at the costs in different types of communities and through the different delivery mechanisms, and indeed it found its way into the report as to the range. I mean, they couldn't be completely specific, but the range of costs, say, per household for implementing the types of changes we were recommending.
By coincidence, Chris Stockwell was in that chair where Linda is last night on this program. Chris Stockwell was the environment minister in the Harris government whose job it was to implement your recommendations.
Right.
After our program was over last night, he said to me, ask him this. He said it would cost $250 million to implement his recommendations. It ended up costing us $2 billion. Ask him about that. So, okay, I'm asking you about that. Were you off?
I don't know that it cost $2 billion.
That's what he said.
Okay, well, I don't know about that. What I do know, though, is that first of all, the Conservative government, who was the government of the day when we delivered the report, and then subsequently the Liberal government, both took the position publicly that they were going to implement the recommendations.
All of them, I think they said.
And they now say that they have done it, and I'm not sure. I hadn't heard the $2 billion figure. All I can say is that the expert advice we had at the time, which was discussed publicly, was, I can't remember if it was 250 million, but it was a large number.
That's what he said anyway.
Right.
Okay.
And the government could have made submissions on those figures as well at the hearing.
Paul.
Chris has always been an exaggerator, but in any event,
Now, Paul, if he sues me for your saying that, are you going to represent me?
I know Chris. Anyway, but at the same time, I think Chris should also advise you that the recommendations in the Walkerton report received worldwide respect right across the world, and people certainly read the report, respected the report, and whether it be academia or politicians or whatever, it received worldwide support.
I'm trying to remember whether the government of the day actually said before the recommendations were even out, yes, we will implement them all. If they didn't say it beforehand, then it was really very close thereafter.
Right.
But the political pressure, I guess, on the government to do what he recommended was intense, wasn't it?
That's correct. That's correct. At the time, obviously, Walkerton was a huge problem locally, but then it became a provincial problem because other small towns and other municipalities realized they had poor delivery systems as well. So there was huge public support for the recommendations that were made.
Now, I warned you all at the beginning that this hour was going to go quickly, and we're literally down to our last few minutes, so I want to do one more thing. Ed Ratushini, to you first. Generally speaking, and you've looked at all of them, right here in this very exhaustive book, which took me a long time to read most of. Do public inquiries achieve what they set out to achieve?
Some inquiries achieve everything. Some achieve most. Some achieve over a period of time, especially policy advisory commissions. Usually, they will make recommendations on the policy matters that won't all be implemented right away, but some will be implemented, others will become part of the public debate and the ongoing evolution of policy. You mentioned the Romano inquiry, for example.
On healthcare.
We've had a number of inquiries on healthcare, including the Hall inquiry, which was probably the start of it all, but there have been subsequent ones as well. And so those sort of evolve. Lately, I think most of the investigative inquiry commissions have been quite successful and have achieved their goal.
Judge Goudge, I want to come full circle with you because you started this program with a bit of a joke about whether or not you'd actually take on this responsibility again. So after it's all said and done at the end of the day, Would you do another one?
I think I probably would, Steve. Whether they're successful or not, I think there are a variety of measures that are used and can be used to evaluate the success. I mean, part of it is the recommendations and how useful government finds them. Part of it, though, is, as Ed's tried to describe, shining a light on an aspect of our society in which there has been a significant problem, and the very transparency of an inquiry, I think, is a benefit to the public. And part of it is, as Dennis and I both were able to do, meeting with those who may have been victims of these crises and being someone that society has clothed with the authority just to listen. And that has an enormously beneficial effect to those who've been victimized by these crises.
Can't underestimate that.
No, it's in a sense a truth and reconciliation process in a small way, but there are a variety of ways in which I think the success of inquiries can be measured, not just in terms of how many recommendations are adopted.
Judge O'Connor, at the end of the day, worth it?
I'd agree with that. I think in recent years, most of the public inquiries we've had in Canada have worked pretty well.
Just pretty well?
Well, yeah, I think they've worked well. I think governments have taken up the recommendations. I think by and large the public's been satisfied with the amount of disclosure and the findings made by commissioners in the reports. Yeah.
I want to thank all 5 of you for coming in tonight for what I thought was a pretty fascinating hour of television. Thank you very much to Mr. Justice Dennis O'Connor, the Associate Chief Justice in the Court of Appeal for Ontario, Mr. Justice Stephen Goudge, the Court of Appeal for Ontario, Paul Cavalluzzo from Cavalluzzo, Hayes, Shilton, McIntyre, and Cornish, who's going to represent me when Chris Stockwell sues us. Linda Rothstein from Palliar, Roland Barristers. Did I get close?
Pellier.
Pelliar, okay. And Ed Ratushny, The Conduct of Public Inquiries. That's the book that he spent so much time on. Thanks very much, everybody.
Thank you.
Thank you.
Appreciate your time tonight.